Hi, everybody. This is Tara Lucke. A warm welcome to everybody. Today's training is about how to sell the value of testamentary trusts to your clients. This is one of my favorite topics. If you know me, you know that I love testamentary trusts. While we just wait for a few people to jump on and do some housekeeping, I'm going to check that our broadcast is going. And I also want to just acknowledge that today I'm hosting these training from the lands of the Tarabulung Bunda people in Bundaberg. And I want to acknowledge the traditional custodians of the lands on which each of you are living, learning, and working from today. I pay my respects to the elders past, present, and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia. So I'll just double check that I'm broadcasting. So I'll just check it on my phone. I can see a few people have joined. So thank you so much. Okay, that looks like it's going through. Any issues with audio quality or anything, let me know. But what we will do is get started. Okay, so if you've just joined, I'm Tara Lucke, founder of The Art of Estate Planning, and today's training is how to sell the value of testamentary trusts to your clients. With this title, I don't want to sound like a used car salesperson with selling, but also I do really want to recognize and acknowledge that one of our roles as advisors, whether you're a financial advisor, accountant, or a lawyer, is to communicate complex legal topics and structures in a way that our clients can make an informed decision and make a choice about what is going to work best for them and their loved ones. So, part of that is a little bit like selling. It does come down to us really fine tuning and honing our communication skills to tell a convincing story to a client and show off the benefits and values of a certain strategy compared to others. So, when I use the word sell, I'm doing that from a I'm just getting a message saying that I've lost the audio. So hopefully that's coming back for you. Let me know in the chat if that is working, just so that I can tell. Obviously, there's no point talking if you can't hear me. So hopefully that's working now. I can see you in the chat, by the way. So go ahead and throw something. Yeah, thank you so much, guys. Okay. So just what I was saying is, when I'm talking about selling and communication, obviously that is with integrity and harking back to our professional duties, but also acknowledging that to be the best advisor that you can, we really do need to come up with strategies and spend time investing in how can we communicate some of these complex topics in a way that a layperson understands how that will work and can make an informed choice. So one of the messages that I'm always trying to spread, and I want to share it again today, is that testamentary trusts aren't just for rich people, and they're not just for super messy situations either. I think there is a preconception that only, super high net wealth or the top end of town clients need testamentary trusts. And one of the things I want to do today is talk about how a testamentary trust can deliver value to young families and just normal Australians. So, before we dive into my sales conversation, one of the things I want to talk to you about is when should we consider a testamentary trust for our clients? When should we put this on the table for a client to consider? So here's my checklist. Obviously, every client needs specific legal advice, but I find that if you can deliver some or have some rules of thumb to go by, then this can be helpful to decide, do I bring this up with this client? Do I give it to them as an option for them to consider? So we had some debate in our Facebook group this week actually about what is the quantum of assets that should go into a testamentary trust. And there was a bit of a variation there, but generally people were sort of saying between $400,000 or $500,000 of assets. So what I like to think of there is after the estate has been administered, will you have at least $500,000 of investable assets in the testamentary trust ready to go? Now, this is just a rule of thumb. To talking to your client, it's important to weed out what are their values, what's important to them. And so you might find that if the client is really concerned about asset protection, then they don't care about meeting that $500,000 quantum. They might be happy to have the testamentary trust for a lesser sum. But generally speaking, if your client is going to take the inheritance, pay off a bit of their mortgage, upgrade their cars, and take all the kids to Disneyland, and there's not going to be anything really left in the testamentary trust, then they might find that they're not going to get a lot of benefit. Okay, I'm just getting told that I'm losing audio again, so sorry about that. I'm wondering if it's my internet connection. Okay. So, what we're talking about here is the cost benefit analysis and equation of the ongoing compliance costs of running the testamentary trust. And that's going to differ for your clients as well, because if your client already has existing family trusts, already works with an accountant, adding a testamentary trust to their yearly accounting compliance may not actually add much more to their accounting bill or anything like that. But if they do their tax returns themselves, go to H&R Block, for instance, and they've never been exposed to a family trust, a company, anything like that before, then dealing with the compliance of managing a testamentary trust is going to be a big bit of a change to them. And so if they're not having, for instance, the tax savings in there or the asset protection benefits, then it's possibly more burden than it's worth. I do have some resources if you want to know exactly what's involved in setting up a testamentary trust after a client has died. I have got a checklist that is on my freebies page. I'll share that at the end. The yearly ongoing compliance is the annual tax return, and then also just complying with the trustee's duties in relation to that highest standard of decision making. So, our second criteria is that there are minors who can benefit from the tax-free or accepted trust income. So that's around $22,000. It depends a little bit depending on the financial year you're in, because um, for this coming financial year, the low and middle income tax offset is being removed. So I think technically when you run the sums, it's like 21,900 per minor beneficiary that they can receive. So if you sort of just say $20,000 to $22,000 of tax-free income per minor, and the minors don't have to be children, although that's normally who we think of, but it could even be nieces and nephews or godchildren, just that there are minors who can benefit. And that also includes future minors as well. So you might be working with a baby boomer couple who don't have grandchildren yet, but they anticipate that there will be grandchildren coming on the scene in the future where those benefits could arise. Another factor is Protection, asset protection, whether that's from relationship breakdown, from divorce risks, or bankruptcy risks. This is another factor to talk about. If your client's really concerned about this, the testamentary trust can be a really great option to bring in that protection. And lastly, if a beneficiary cannot manage their inheritance appropriately, and that could be for a host of reasons, whether it is because the beneficiary is just a minor, or even maybe because they are spendthrift, there's substance abuse problems, there's a disability, that type of thing. So it just really does depend on the nature of the concern. And obviously, when we're dealing with this category, more specific advice needs to be given. But if this is something that's coming up in your initial meeting, then it's worth putting on the table. Is a testamentary trust going to be one of the solutions that will help us here? Okay, so let's go to the main topic, which is selling the value of a testamentary trust. So I want to use an example as if I was meeting with a client. So this was our initial meeting or our initial phone call. So Dan and Ava come to you. They have 3 children. They're sort of in their mid 30s, early 40s, and they have come to you saying, "We want to get our wills done." So what they're probably coming to you thinking about is a simple will, so without a testamentary trust. And I was always taught to call this an "I love you" will, where basically, here's Ava. If she dies, she leaves everything to Dan. "I love you, my beloved husband. I leave everything to you." If Dan dies, then everything goes equally between the 3 children. And because they're under 18, they have to nominate someone to manage that money for them. So in this case, they've nominated Kylie, who is Ava's sister. So even though I've said no testamentary trust, there is actually a bit of a testamentary trust here, because what we've got is a bare or a fixed trust where Kylie is holding the inheritance for each of those children, but it's not a testamentary discretionary trust. Each of those children is entitled to their discrete third of the inheritance, and it's for a discrete amount of time, usually once they turn 18. If you do want to learn more about the difference between the bare testamentary trust and the testamentary discretionary trust, which is what I'll be talking about today, I do have another training called Different Types of Testamentary Trusts in the group under the guides section. And that's really worth looking at, where we just break down really simplistically the different structures and how they work. So, trying not to get off topic, Ava and Dan are probably going to come to you thinking they're just going to get an "I love you" will, right? So, our role is to talk to them about whether a testamentary trust could be useful for them. So, we go through our category and I say, yeah, look, there's minors who could access the accepted trust income. We've got 3 minor children. I would suspect, once I talk to them, that they are concerned about the survivor repartnering and the relationship breakdown risks that could arise. So I will talk to them about whether they would get value and want to look at a testamentary trust as an option. So just so that we're all on the same page, oh, and I'm just getting a note saying that the video's not working. Let me just check. I'm sorry about this. I think it's an internet problem, which is really disappointing. So I'll just double check what I can see from my end if it's coming through. Okay, looks like it is working. So anyway, sorry about that. I can't troubleshoot it while I'm giving the presentation. The replay will be available. So if you do want to rewatch it, you can do that as well. So when we're talking about the testamentary trust will, what we're mainly talking about here is this fundamental feature where we're separating control from the right to benefit. So that's the key feature of nearly all trusts, right? We have control sitting above that blue line, mostly resting with the trustee and potentially any other optional roles like the appointer, principal, guardian, and the trustee holding the inheritance in the trust for the benefit of the beneficiaries. And in this case, the entitlement of the beneficiaries will be discretionary. So none of them will have a set entitlement to the income or capital of the assets of the trust. They have a right to due administration of the trust and to be considered by the trustee, but not to demand a distribution. They have a right, following our re-OE's case, for the trustee to give them each real and genuine consideration. But nowhere does it say those 3 children are entitled to a third of the income or the capital. So the trustee manages the trust for the children, each year makes a decision and exercises their real and genuine consideration about how to allocate the benefit of the trust. So this is the testamentary trust that we would put on the table to them. And I would focus on 3 things for this type of demographic where we've got a young couple with young children. Number 1, I would talk to them about, is it important for them to protect the inheritance from the survivor repartnering, having a new spouse, potentially having more children? Is that relevant to them? Secondly, I would talk to them about the tax-free income. And I think this is where our sales skills really come to light, because I don't know about you, but me and a lot of my friends, once you start talking about tax, our eyes glaze over. So what we need to do is be able to translate this into something that firstly they understand, and secondly they see the benefit of, so that they can make a choice as to whether this is something that they want to invest in for their family. The third thing I would focus on is looking at protecting their children from wasting their inheritance. So there's a whole range of benefits that testamentary trusts can deliver to a client. But I think it's easy to just focus on the 3 big ones that are really going to make a difference and hit home to the clients, and particularly keep them awake at night, really get them thinking about the consequences of them having the testamentary trust and not having it. So to dive into exactly how each of those factors would work, I would talk them through a couple of different scenarios. So I'd say, are those things important to you? Let's explain how they would play out. So unfortunately, we're going to pick on Ava, and Ava dies. Now, after a suitable mourning period, Dan meets his new spouse. So, what happens to that inheritance from Ava? And let's just say, hypothetically, they have a home together, and Ava has some money in super, and she's got 3 children. So, responsibly, she's worked with her financial advisor, and she has a decent life insurance policy. Let's say it's $1 million. And so, what I would typically see or imagine as like the most standard structure here is that the home is probably going to go outright to Dan, just straight to him, keep it nice and simple. But we've got that $1 million in super to protect, that we can pass into the testamentary trust. So what happens to that money? On the left, we've got our simple will. So under the simple will, the I love you will, if Dan receives that directly, remember it was going from Ava to Dan and then to the children. Dan has survived, so he just gets everything, the house, the life insurance, everything in his own name. He takes that into that new relationship with his new spouse, and it just forms part of the property pool of that new relationship. And so if they go through a relationship breakdown and separate, it's on the table, right? That money is there. Let's say the relationship doesn't break down. Dan and his new spouse live happily ever after. until Dan dies. So the money that came from Ava, which was really meant to be for Dan and their children together, is now part of Dan's will and part of Dan's estate. And Dan has the 3 children from his relationship with Ava, plus a new spouse, potentially future children as well. So Ava's totally lost control about how Dan gives that out. He very well may at this point, and I've seen this happen a lot, especially if the children from Ava are adults now and he's got minor children with his new spouse, say, well, actually, I've looked after my older kids, but I'm leaving my minor kids who haven't had the benefit of me being there and paying for them. So I'm going to give them the lion's share of the estate, or I'm going to give it to my new spouse for her to look after our minor kids together. So who knows if Ava's children are going to end up with Ava's life insurance. It's also exposed to family provision application risks from Dan's new spouse, right? If there's a challenge against Dan's estate from the stepchildren or the spouse, the inheritance from Ava is part of that pool. Compare that to if we use the testamentary trust. So we've got the $1 million going into the testamentary trust. That money does not automatically go into the property pool if Dan and his new spouse separate. Okay. We could spend a whole hour talking about family law here, but what I will say is that the onus of proof is reversed. So rather than Ava's life insurance automatically going into that property pool for consideration in a property settlement, it's excluded. And Dan's new spouse has to try to drag that in as property of the relationship. So Dan goes from the back foot to the front foot by having that testamentary trust in place for him. If we think about the happy family scenario and there's no relationship breakdown, but Dan does die. Well, Ava is not relying on Dan's will to give that $1 million life insurance to her kids. Because it goes into the testamentary trust, that is not part of Dan's estate. Dan gets to potentially control it if that's what Ava chooses while he's alive. But if he dies, the money stays in that testamentary trust and new controllers step in. So Ava can rule from the grave to say, well, who's going to control this after Dan? And she might put Kylie or the kids in if they're over 18. So we're not relying on Dan's will. She knows that that money will go to her kids. There's definitely risks there that Dan could try while he's alive to circumvent the trust and, make capital distributions to himself or wind it down. And there's always a conversation about how much autonomy do we give the surviving spouse over the trust and the control. But if we just look at it super simply, by even having the testamentary trust in place, suddenly Ava's got so much more control over what happens to that money than if it goes to Dan in his own name under an I love you will. So she's got peace of mind that she's setting up a plan for those children to get the money. And if it does happen to be a family provision application against Dan's estate from his spouse, for instance, leaving New South Wales to the side, in every other state where we don't have notional estate rules, that testamentary trust does not form part of the challengeable pool of assets available to satisfy the family provision application. So the testamentary trust just adds so much more peace of mind and certainty and protection to the inheritance when we're looking at a young couple and one of them dying and the survivor potentially repartnering. I will just say, in New South Wales, the testamentary trust could be brought in to satisfy the family provision application under the notional estate rules. So the equation is a little bit different. But the starting point is that it's not on the table in a relationship pool, and it's not automatically gifted under Dan's will. Ava's not relying on Dan 20 years later to do the right thing by her children. So let's talk now about the tax, okay? And we can assume maybe there's a 5% average return on that $1 million of capital. So let's say it's earning about $50,000 of income in the inheritance. So again, if we look at this and say the simple will, the I love you will, it's all gone into Dan's name, Dan's probably got a job, right? He's already on a marginal tax rate, already earning income. That $50,000 just gets taxed in Dan's tax return on top of his salary or other income that he's earning. And it might even, so it's going to be at that tax bracket, whatever that is, and it might even push him up a tax bracket. This is $50,000. It's a big jump. And all of that gets taxed in Dan's name. And then Dan is paying for the costs for the young kids because they're still minors at this point, with his after-tax income. So that's standard. Like, that's what everyone does. That's what the situation we're all probably in now. But we can actually do better than that with the testamentary trust. So because Dan might control the $1 million and the income that it generates in the trust, but he doesn't own it, he can actually allocate the income between the children each financial year as much as he likes. So each of those minors are entitled to receive about $20,000 to $22,000 of income without paying tax on it each year. So that's about the first $60,000 of income that the capital in the testamentary trust generates each year can be tax-free if they choose to. So rather than it all being taxed at Dan's name, he can actually access that full amount of the income tax-free and use that to pay for the school fees, medical bills, sports, anything for the children as tax-free income. This is a game changer, and this is the only environment where you can really get that kind of treatment. Even if he went and set up a family trust, an inter vivos family trust today, those children, while they're under 18, can only get about $400 each year tax-free before they pay the highest marginal rate as a penalty. So that's $1,200 of total income that can be allocated tax-free from a family trust versus $60,000 because we've got 3 children from a testamentary trust. It's a game changer. And this is why I love testamentary trusts for young families, because if you have lost a breadwinner, if you've got a family that's gone from 2 incomes down to 1, that's huge. That's a huge impost on a family, especially when you think about the childcare costs, the extra household support that they might need to bring in, the extra expenses to support that surviving parent, and the loss of that income from the salary of the deceased parent. This can just be a game changer for the financial future of a young family. So that's why, I'm a lawyer, I don't sell life insurance, but that is why I think it's really important that life insurance goes hand in hand with the testamentary trust conversation so that there is money there, and that you do look at using a testamentary trust if it's going to stack up for a client, because it can really just change the trajectory of their financial future. So in this scenario, for instance, there's a chance that Dan doesn't have to even dip into that capital, that $1 million capital, to fund the extra costs and living expenses for the kids. You know, he can if he wants to, but with 50,000 tax-free income available every year, maybe he doesn't need to. And so that just grows and grows, and you can also accumulate the unexpended income as well. So the difference here for a family is astronomical. Let's talk about that third scenario, that what happens if Dan and Ava both die together, which is awful and, every parent's worst nightmare. Under the I love you simple will, where everything goes to equally between the three kids, if they're under 18, Kylie is going to manage it for them. Once they turn 18, there's really not much that Kylie or anyone else can do to protect them from wasting their inheritance beyond giving, moral guidance and support. If they're going to get control of their third of the inheritance, and they can do whatever they want with it. And we've all heard these horror stories of kids just blowing through their inheritance, being total spendthrifts and nothing being there for them when they need it. A lot of people think, oh, that's fine. I will just say in the will, my simple I love you will, they can't get the money till they're 21 or they're 25. But we have got the Saunders and Vautier rule, which means that if they are absolutely entitled and over 18, they can call on their inheritance to be paid to them. And it's hard to get around that. So, putting in those older ages doesn't really achieve a lot. Compare that with the testamentary trust will. The kids are protected. The children do not get control of their money when they turn 18. They can receive the benefit of the income or the capital at the discretion of the trustee, but Dan and Ava can choose who are they going to put in as the trustees of the trust. They can appoint their trusted friends and family members to manage the trust until a specified age. And because of the way the testamentary trust works, you can nominate that the kids don't get control of the trust until they're 21 or 25 or even 30. And it's not able to be subverted by the Saunders and Vautier rule. So you can really make sure the money is there available for the children, but they don't have financial decision making and autonomy over that until they are financially mature enough, and that the trusted friends and family in the circle get to decide. So there's a couple of ways you can do that. We talk about it in my TT Precedents Club all the time. Do you use the letter of wishes or memo of directions to specify at what age children get control of the trust, or do you hardwire it in? There's options there. And this is something that you would talk to the clients about, get their instructions on, and tailor something that suits them. But if we recap on those three advantages, number 3, which we just talked about, is protecting the kids from blowing their inheritance and being financially immature. Number 2 is the tax-free income. And the first one is just giving the family more control and putting the surviving spouse on the front foot when it comes to new relationships that, let's face it, are probably going to happen when we're dealing with this demographic. So that's what I wanted to say about young families. Now let's look at that baby boomer generation. So meet John and Sue. They've got 3 adult children. They're all partnered up, and there's grandchildren on the scene as well. So what are the things that I'm going to target in my conversation with John and Sue? Because again, John and Sue may actually come to you already knowing about testamentary trusts. I do find that they're more common. There's more awareness of them in that demographic, but they very well may just have always done very simple I love you wills. And again, we've got to say, well, should we put testamentary trusts on the table? And I just want to keep reiterating, yes, it's an upsell, but what we're doing, I think, is just letting them know their options, and then they can make an informed decision about what aligns with their values and their legacy goals. And the best way we can do that is by communicating the concepts, the benefits, and exactly how the structure will work as simply as possible so they can make that informed choice. So the first thing that I will talk to them about is not the survivor of them necessarily entering into a relationship. Okay, sorry, I think I dropped out again. So I'm back. So what I'm talking about here is not the survivor of them going through that relationship breakdown, but their adult children um, going through a relationship breakdown and the inheritance being exposed to those family law risks. The second one is again looking at the tax free income, but for the grandchildren this time, particularly because that inheritance can go a lot further for each child who has children of their own if they can access that tax free income. And then lastly, um, this may or may not be relevant, but if they do want to look at ruling from the grave, protecting children who are financially immature, the Testamentary Trust can give them a little bit more options about that as well. So, did you hear me say divorce protection? I think for a lot of baby boomers, that's so critical. They're really concerned about the in laws, the daughter in law, the son in law, the relationship. Um, Breaking down and the money that they have worked so hard to accumulate during their lifetime, being caught up in those family law proceedings and leaving the bloodline. So, again, I've talked about this at the beginning. It's the same equation. It doesn't prevent the inheritance being paid to a daughter or son in law, but it does just put that child on the front foot in terms of, defending that this is not part of that relationship property. And this is a big one. I think this is probably the main thing that might motivate your clients to embrace the testamentary trust. The tax-free income, again, for instance, for me, I've got a young son and a baby on the way, and I'm making sure that my parents are leaving me the inheritance in a testamentary trust because I want to access that tax-free income on instead of paying everything in my marginal rate. And at our it will just go so much further so that inheritance will last longer. We can do so much more with it, and it really just maximizes that legacy. So, tax free income, you can't get it anywhere else. It has to be, the asset has to be owned by the testator when they die, and they have to have a testamentary trust in their will before they die to get environment. So, I guess I kind of say to a client, yeah, we can do your estate planning. Um, we can get your will done if you want, but I like to use this camping analogy where the simple will is a bit like going camping and you take the tent, but you don't put up the fly. You know how a tent has the internal tent and then it's got the waterproof fly on the outside. Um, yeah, you've got a tent, you've got a roof over your head technically, but in case of bad weather, you're not protected. The testamentary trust is the fly in the tent that actually means that even if there is bad weather, you have a warm, safe night's sleep and you have got full protection. So for a couple of $1,000s more, just generally speaking, in terms of the costs that people are charging for testamentary trusts, why wouldn't you get the full protection for your legacy and your inheritance? So, we've pretty much come to the end of my sales tips. I do have a little cheat sheet for you called the 9 Strategies to Overcome Estate Planning Inertia. It's a freebie that you can download. I'll post it in the group. I'll just see if I can do that now. Give me one moment, and you can all download that, and it's got, there's about 9 different demographics, where we go through the main conversational sales points for those clients about what you can cherry pick that is really going to resonate with that client to get them over the line and to really see the benefits of the testamentary trust for them so that they can make an informed choice. So here I've got the baby boomer couple with adult children, but there's all different ones in there as well. So that brings me to the end of the presentation. Is there any questions? I do want to thank you for bearing with me while that audio was dropping in and out. I'm very sorry about that. If there's any questions you have, or even any other points that you like to use to help communicate this concept to a client and get them across the line, I would love to hear it. I think, focusing on these types of practical and soft skills really makes us better advisors as well. Anything that we can do to make this complex topic simple to the layperson who's not that experienced with trust is just going to make the whole process smoother for the client and increase their customer satisfaction, as well as helping us get better instructions and make sure that together we collaboratively customize an estate plan that is going to achieve the client's exact objectives. So I don't think there's any questions. I want to thank everybody who has joined me today. I really appreciate that. And I can see a question. Thank you so much, Tanya. So, do I recommend only setting up the trust for children when the couple is older? So, my general rule of thumb is, and it depends. It really depends on the assets about what's going to go into the testamentary trust. But where you've got a couple with young children, I would usually set up the testamentary trust for the surviving spouse right away. Usually a single testamentary trust, if there's going to be, 10 plus years where third parties are going to have to manage that testamentary trust for the children, then I would usually go with a single testamentary trust for the surviving spouse and the children. If we're looking at that John and Sue scenario with the baby boomers, where a lot of their assets are owned as joint tenants, like joint bank accounts, joint properties, and maybe in super where there's reversionary pensions, you'll probably find that there's not a lot going to actually pass through the estate in the first instance. And so in that scenario, yes, Tanya, I would probably usually find that they will defer establishing the testamentary trust until the death of the second spouse. So after both of the couple have died. But it just depends, honestly. It depends on how concerned they are about protecting the inheritance from the surviving spouse. For instance, a lot of people now are getting really worried about elder abuse. I think I put on my slide here, women mourn, men replace. Oh, my head's in the way. I'll just see if I can move my head. No, that didn't do it. Here, yeah. Women mourn, men replace. So particularly if you're concerned about if the surviving spouse is concerned about leaving everything to their survivor and then them repartnering and being vulnerable, then you may look at setting up the testamentary trust. There's all different strategies. I think what we're talking about today is, the decision of even to look at testamentary trusts or not. Are we going to go there with the client and put it on the table, and do the clients want to have that discussion? And then it opens up a whole range of strategy discussions to customize. But yeah, my very simple rule of thumb, baby boomers where everything's not is held as joint tenants, and in super, defer setting it up until they've both passed and then look at it for the adult children. Oh, I can see more questions. Thank you. I was asked to draft a financial agreement for a second marriage. How closely related is it to testamentary trust discussions with clients? Great question. And I really do think that the financial agreement can be a really good estate planning tool as well. I know, like for me, I would never draft one myself because I'm not a family lawyer and I'm not experienced in that. But it is definitely worth having that in your toolkit of options because it can just mean that the surviving spouse can get certainty that if the inheritance that they've received from their first spouse, which is ultimately intended for the children from the first relationship, if the financial agreement says, well, actually, though those assets from the first spouse are not part of the property settlement with the new spouse, then that can really just help give more comfort that the inheritance isn't going to end up outside the bloodline. And generally speaking, I think they can make them binding on the estate as well. And it certainly is evidence when looking at family provision application and challenges against the estate about what the parties intended, especially because, one of the parties is now deceased. We've got a formal agreement about what they agreed and thought was a fair bargain. So I definitely think that they can play a role. I mean, it's been very simplistic what I've spoken about on the family law context today, and it is hard to ever give your client an ironclad guarantee when we're talking about family law and trusts and testamentary trusts. So I really tried not to do that, but I do also just say, look, you're really giving yourself a leg up by having the testamentary trust. But it's very, lots of nuances there on the family law front. I hope I've answered that for you. I'm just looking through the next question. Okay, would you record in your file notes that TDTs were discussed and recommended and the clients decided against it? Yes, definitely, I would. In fact, if you use my file note template from the Works Precedents package, you'll see in there that there's a point saying, these are all the factors we talked about with testamentary trusts, and they decided to proceed or not proceed with them. And I just think it's prudent that you do record everything you've talked about. It's kind of funny actually because there's a lot of estate planning lawyers who don't offer testamentary trusts, and there's currently I think the state of play is there's no recourse against them for not even mentioning a testamentary trust. And if they fail to let the client know about these amazing advantages, then I don't think there'd be a claim against them, or there's certainly not people pursuing negligence claims against them. So, but when you kind of take a step back and you go, well, why shouldn't they be telling clients about this amazing tool that is available to them? So I think, by not recommending a testamentary trust, I don't know that you're exposing yourself as a practitioner, but for me, it's more about my integrity as being able to best serve the client I can, and knowing about these as a tool and then, not recommending it. But I think, any file note should show an accurate record of what was discussed and the advice given. If I really believe that a client should use a testamentary trust, like we're talking like a multi-million-dollar asset pool or something, then I would also put it in my cover letter and attach my flyer explaining the benefits and just say, I've recommended it to you for these reasons, those 1, 2, 3 reasons, and you've decided not to proceed, and that's fine. So yeah, I hope I've answered that. I mean, I am probably of the view that it is negligent not to recommend a testamentary trust for someone who's suitable, but I know there's also another school of thought saying that a lot of clients can't comprehend how complex these structures are, and we also have to be careful about pushing them on to clients who don't understand what they're entering into. So I think it's a really fine balance where you have to exercise your discretion. I'm just looking. Thank you. I'm loving all these questions, and I'm just going to have a look on the phone so that I can see. Yeah, Yona. So if you're not a family lawyer either, I would just talk really high level. I would just talk about it generally and then refer out and work collaboratively with a family lawyer and get them to get that advice. That's what I have done in the past. And I think we can sort of say, here's a tool that is worth getting more advice on, and pursuing and, thinking about. I think just because you're not a family lawyer, you're not necessarily off the hook about not suggesting it either, but I'm definitely not recommending that you work outside your area of specialization and draft it up. But I think we can always work collaboratively and recommend a family lawyer, at least give them some preliminary advice about how that might work. And thank you for your question, Joseph. So if an older couple had 3 adult children and each adult couple were in a couple and 1, 2, 3 grandchildren respectively, would you recommend getting 3 testamentary trusts, 1 for each adult child, or if you just had 1? Yeah, that's a really great question. So again, this is something that I would talk to the client about to customize for them. So there's pros and cons about whether you go for a single testamentary trust with all children or a multi-TT strategy, 1 trust per child. When we're dealing with adult children living their own lives, then usually it comes down to the relationship between the children and how much autonomy they want and need. Because there's no point, in my opinion, setting them up in a structure that is guaranteed to fail from the beginning. So I think there's a general I'll get my little pen out. I do think if we're talking about protection from family law, there's a bit of a spectrum where, as I said, no testamentary trust. I'll just remove your question so that you can see my full screen. Not having a testamentary trust, using the I love you will, means anything that adult child receives is just part of that relationship property pool to be considered in a family law property settlement. So I would say you're pretty much game over if you're not using the testamentary trust. Now, I would probably also never say that you're going to get 100% protection. Even maybe that's a bit too close to the 100% when it comes to family law. But I would think that with adult children, a single TT for all children is going to be closer towards that 100% versus if they have their own testamentary trust, where they are, particularly if they're the own controller. So there's like if my parents set up a testamentary trust for me and I was the trustee and appointor, and there's a big chance that it's going to look and feel like my money, especially if all the benefits coming to me. And so that's where these alter ego arguments come in. So, if a testator is really, really concerned about family law protection, if that's their number one thing that they can't get past and they really want that, then yeah, maybe you would put all 3 children into a single testamentary trust. But if you put them into a single testamentary trust and those kids can't get along, they can't manage that trust together, and they either decide to get, notionally bought out of the trust, or they just wind the whole thing up, they suddenly go from here down to here, which is a really bad outcome, right? So they're probably better off being here in a structure that is sustainable, that still gives them the other benefits as well, protecting the inheritance for their children, the grandchildren, so they don't blow it, and also the tax-free income if it's something that they can sustain, because the trusts are meant to be long-term wealth accumulation vehicles, right? They're meant to have the funds in there for up to 80 years. So we want them to go the distance, and we have to set the structure up right. In terms of getting the trustees, again, it's really nuanced, and there's a lot of different considerations there about decision making rules for multiple trustees. They have to be made jointly. What happens if one of them dies and there's the children of the deceased children who are intended to benefit the third? Then do we need a representative to be on the trusteeship to represent their interests? So this is where I think, tailored, customized advice is important. This is the type of stuff we talk about in our TT Precedents Club hot seat like every week, to how to get that balance right based on the factual scenario. But these are options. And one thing I'll just say, I'd say moving up from the own TT, maybe you get a little bit further along that spectrum where you don't have the sole or the nominated beneficiary as the sole controller, like following that Morton and Morton decision, for instance. So there's things you can kind of do to boost the protection, even with a multi-TT, but it's very much a spectrum. It will depend on a whole host of things, not just who the trustees and beneficiaries are. Who the beneficiaries are spouses included? Where has the money actually gone? How are decisions made? What's the full factual scenario that we're looking at? So it's hard to say, but I think what we try and do is set something up that can last the distance and meet the family's needs. So I think I'm saying the same thing over and over. So what we might do is wrap it up, because I do actually have to run to our TT Precedents Club hot seat to workshop some of these types of questions for people. So we might turn it off there. Don't forget to get your free download. The link I put up the top, and I'll post that again in the name of the group so you can see it. Thank you everyone for all of your awesome questions. I'm happy to keep this conversation going. If you're watching the replay, I can see your comments, so we can keep that going. I think this is, a really interesting part of estate planning, and I'd love to hear all of your thoughts and experiences as well. But for now, I'm going to wrap it up. Thank you everyone who joined me live, and I will see you all next month for our topic about how can a death doula help your clients. That's on the 8th of December, and it will be our last session for the year. Thanks, everybody. Bye.